All right, I will call the Senate Judiciary Committee to order. We do have an overflow room. It is right next door. I think it's number 2134. It's the Commerce and Labor, Health and Human Services room. And I will ask the secretary, will you please call the roll?
Senator Harris, Senator Orenshaw, Senator Dondero Loop, Senator Wynn, Senator Hansen, Senator Krasner, Senator Stone, Chair Scheibel.
Here. All right, we have two bills on our agenda for today and a packed house. So I'm going to let you know up front that after the bill presentation is concluded, the members of the committee will have an opportunity to answer questions. Once all their questions have been answered, we will go into testimony in support, opposition, and neutral. We'll do 20 minutes of each for 1 full hour of testimony, 20 minutes in support, 20 opposition, 20 in neutral, and we'll divide that up between people in person here, people in person in Las Vegas, and people on the phone as evenly as possible. And with that, I think we are ready to get into our first bill presentation, SB 227, whenever you're ready, Senator Spearman.
Good afternoon, Chair Scheibel and committee members. I am pleased to be back in the Judiciary Committee today to present Senate Bill 227, which primarily creates the crime of intimidation as it relates to the use of symbols of hate. The bill makes several other changes to the law related to this focus on intimidation, which I will explain today. And I have two people that are going to co-present with me, Reverend Robert Bush and Mr. Elliot Malin. I think Reverend Bush is here, but yeah. So they will be presenting with me, and then after they finish, then we'll be open for questions. Typically in a bill presentation like this, I would start by giving some background information not contained in the bill to make clear to the committee why the bill is needed or what problem it is intended to solve. Where Senate Bill 227 is concerned, that will not be necessary because I'm sure that the bill was drafted with the background information included for everyone to read. Accordingly, this history, understanding the power of symbols to intimidate and terrify, is that important. So, Chair Scheibel, I invite the committee to read the preamble to the bill along with me now before we give a further overview. All of those whereas clauses were developed and designed so that people would have a background information. And I just want to give a personal story that is a background. In 1969, my sister and I were among 15 students to first integrate a high school in Alabama. And I was a brand new freshman, and I remember riding the bus that day, and there were hardly any people on the bus. And so I thought, wow, this is going to be pretty cool. We don't have to fight for seats. Only to realize a little bit later that there were hardly any people on the bus because of integration. And when we arrived at the high school, we saw the Ku Klux Klan in full regalia out there, and they were standing in front of the door, blocking our admittance. Everybody else sat on the bus, and I guess call it young and dumb, I don't know. But I got off the bus and went straight toward the door and said, "Excuse me," and they moved. That was only the first time that I experienced, not the first time I experienced hate, but it was one of many times that I would experience hate and hateful acts and hateful speech as a result of being the first to integrate that high school. I was often called the N-word, and there were people who often said or did things that were familiar to them with slavery, and there were a lot of people who said to us, "You shouldn't be here." And I think those of you who know me now know that that didn't sit well with me then, and it doesn't now. I was threatened by the principal of expulsion because I was suspended a few times because I would not let people call me the N-word. And I would not let the teachers use some type of slang that sounded like the N-word. Instead of pronouncing Negro, they had a tendency to merge the N-word with that, and I wouldn't allow that for me. And the last time I was in the principal's office, I remember he said, Well, you one of them troublemakers from up the road. And things like that don't happen down here. So I think what I'm gonna have to do, I'm just gonna have to suspend you for the rest of the school year. I said, okay. And I grabbed my books, and he said, you like that? I said, yes, sir. And he looked kind of puzzled. I said, you know, I've been trying to figure out how I could go to Montgomery and work with the NAACP on a lot of these issues about integration and racial justice, and you just gave me the opportunity to do that. So thank you, sir. And I grabbed my books. He said, wait a minute, wait. So now he doesn't want to suspend me. And I give you that background story just to say there are some symbols of hate that you don't have to define, because historically they mean the same thing today as they did in 1860, as they did in 1855, even as they did in 1969. And so now let me walk through the bill. Section 1 creates the crime of intimidation, which is committed when a person etches, paints, draws, or otherwise places a symbol of hate on public property or in plain view of the public with the intent to threaten, intimidate, or deprive a person of any right secured under our state or federal constitutions, or to retaliate against a person for exercising any such right. The section also defines symbols of hate to mean a symbol, image, or object that expresses animus on the basis of race, color, religion, ancestry, disability, sex, sexual orientation, national origin, or gender. And I will say at the onset that Mr. Malin is here because he's going to help clarify the symbol of swastika. And we do have a couple of amendments that I'll read after the bill, so I'll read this first so we can put that in context. Section 1 also sets forth the penalties for committing intimidation. These range from a misdemeanor for a first offense to a Category D felony for a third or subsequent offense. And these penalties can be imposed in addition to any other penalties that a court may impose that are related to the same conduct. A victim of intimidation is not precluded by this bill from seeking any other available legal remedy, and Section 8, in fact, adds intimidation to the list of crimes for which a victim may bring civil action. Section 1 also makes it clear that this bill in no way intends to prohibit a person from exercising his or her free constitutionally guaranteed speech. Section 2 makes clear how the law will interpret where an act of intimidation is deemed to have occurred, and Section 3 authorizes a person who believes they are a victim of intimidation to seek an order of protection from a court in the same way that a victim of harassment or stalking would. Several sections of the bill then add intimidation to the law in relation to orders for protection. These, again, are provisions that currently address harassment and stalking, to which the bill adds intimidation. Next, Section 10, which addresses what happens when a child commits an act of intimidation and is therefore found delinquent by the juvenile court. It is vitally important that we teach our children not to hate. And let me pause right there. One of the things that happened to me in that school in Alabama was I had an opportunity to make friends, real good friends, with one of my classmates who happened to be white. And when I corrected the teacher in Alabama history from saying the combined words of Negro and the N-word, she came up to me later and she said, I didn't know that. She said, all of my life, that's what I heard my parents say and my grandparents say. That's what we say in our house, and I had no idea. And so I had an opportunity to share with her what that meant to me and what it would mean to anyone else of my ancestry. We were friends and stayed in contact a long time, I guess until about 25 years ago, and we just kind of lost contact. But the reason I bring that is because children are not born to hate and to discriminate. That's learned behavior. And so if you learn behavior, you can probably unlearn behavior. It takes some time, but you can do that. That's why, in addition to the common punishment of suspending a child's driver's license or delaying the date in which a child can apply for a driver's license, requires a juvenile court order for a child who commits intimidation to participate in an educational program designed to reduce prejudice and promote empathy. And that program does not have to be established. It's a program that's already available through the Southern Poverty Law Center. And 1865, which is here to testify, will say more about that then. Lastly, sections 14 and 15 of the bill provide for the early termination of rental agreement by a victim of intimidation in the same way that a victim of harassment or stalking is currently allowed to terminate such an agreement. I told you the story at the beginning, and I've added some other comments. just to say that in my life, I have experienced a lot of these things. And I've experienced them so much so, you don't have to tell me that's what it is, I can smell it. And I know when it's being covered up. And I understand when it is intentional. Now, I know that in a court of law, you have to justify all of that, but I'm just saying to you, it has been my experience that when people want to intimidate and when people want to pursue hatred based upon any of those categories, they have the ability to do so, and in many cases, they have learned how to disguise that. And what this bill is intended to do is to discourage people from intimidation by these symbols of hate. And I'd like for Mr. Malin to come now and testify about the swastika, because I learned something talking to him about that. Thank you.
Good afternoon, Chair Scheibel, members of the committee. Elliot Mallon for the record on behalf of the Anti-Defamation League. First, I want to thank Senator Spearman for bringing us into this conversation. I can never have the same experience as Senator Spearman, but I can have one that is similar. When we moved into our house, we found swastikas out front in our neighborhood. When I was in college, I lived in the Jewish fraternity house, and we had golf balls with swastikas hit at our house. Unfortunately, this is a reality here in Nevada, in our communities, in our country, and around the world today, as anti-Semitism has been one of the fastest growing and most widespread hate crimes in America. And again, I want to thank the senator for having a conversation. We wanted to make sure we were clear on what swastika means, because swastika can have a legitimate purpose. The AAPI community, specifically those that practice Hinduism, Buddhism, and Jainism, utilize the swastika as a symbol of peace. And we want to make sure that that is protected and continue to be protected. When we talk about the swastika, we always talk about the Nazi swastika, which is different than the one that is used by those for the symbol of peace. And so and we were very thankful for the senator agreeing to our conceptual amendment to better define that, to ensure that we mean Nazi swastika and not targeting those who do utilize it for legitimate purposes. So thank you, and we do really appreciate the conversation that we're having here today and all the stakeholders that we've had the opportunity to discuss this with. The Anti-Defamation League is an organization that we speak out about anti-Semitism, but we also speak out against hate and hate symbols and how they are used. And so this is a topic for us that we are passionate about and passionate to get to the right place with it. So thank you, Senator Spearman. And if you have any other questions, good.
Thank you. I have Reverend Bush, who is in Las Vegas. He's with the National Action Network. Permit him to testify.
Good afternoon, Chair, and good afternoon, Senator Spearman and members of the committee. My name is Robert Bush. I'm the president of the National Action Network Las Vegas. We are the leading civil rights organization in the country and also in Las Vegas. And I'm here today to show my support, and I represent a large part of the community that need Senate Bill 227 to become law. I'm also a graduate of Rancho High School. My family has lived in North Las Vegas off of Cheyenne and Civic Center since 1970, and we moved there at a time when blacks weren't supposed to be off of the west side of Las Vegas. We had riots in our schools, and always the threat of running into a white mob when walking home from school. That was about 50 years ago. Approximately 1.5 to 2 years ago, our organization got 3 individual calls about a noose that was put up on a construction site being built by Madison Square Garden called the Spear. The next day after the noose was taken down, swastikas were put up around the bathrooms. Madison Square Garden had them painted over, and they would just reappear the next day. And I thought to myself, certainly there's got to be laws against this egregious act of intimidation, only to find out, to my surprise, Nevada has none. It's amazing that we're still dealing with systemic racism and not having racism laws on the books to protect people. It's sad that in these modern times, there's still a need to address the problem of racists who use nooses as a means of threat and intimidation. But we can't ignore the truth and the truth that there are some who would like to take this state back to the 1960s. To hang a noose, which is a symbol of lynching and killing somebody because of the color of their skin, shows hatred and real bigotry. The noose isn't just a symbol of hatred, it's a threat of violence and should be treated as such. A rope, to us, represents a threat to human life, and that person, when found out, needs to be dealt with by the authorities. Sadly, the federal government has relinquished its responsibility to protect the civil rights of citizens by relying on states to investigate hate crimes. Although there would be limitations and challenges in bringing successful hate crime prosecutions, each case must be taken seriously by this legislation and by this state. There must be vindication, as with the instance of those 3 individuals who were run off of a job by a noose. There must be vindication and rights for victims when prosecution is warranted by the facts and by law. I'll tell you that blacks who are on the job site of the spear have had their lives, they have significantly, and their psychological makeup changed forever. It would be irresponsible in our duties, in your duties, as legislators or as Nevadans, to ignore that this is happening. We can't just sweep it under the carpet. We at National Action Network and you as leaders in the state and our communities should have no tolerance for nooses, swastikas, or any other symbols of hate that attempt to intimidate anyone. This bill will strengthen Nevada's hate crime statutes. Perhaps no other symbol, even a burning cross, depicts the horrors of racial violence perpetrated against African Americans and others more than nooses. Nooses epitomize the essence of discrimination. The noose not only symbolizes racism, but also serves as the actual murder implement for the lynching of black people of the color of their skin. As the NAACP said in 2007, in their state of emergency report, the hangman's noose is a symbol of the racist segregation era violence enacted on blacks. It is an unmistakable symbol of violence and terror that whites used to demonstrate their hatred for blacks. At that time, President Bush agreed and said, for generations of African Americans, the noose was more than a tool of murder. It was a tool of intimidation that conveyed a sense of powerlessness to millions. He went on to call the lynching of blacks by whites a shameful chapter in American history and denounced noose displays as a symbol of gross injustice. Sadly, the hangman's noose has appeared at the last 2 major construction sites that Las Vegas claims to be proud of, Resorts World and from a beam at the multi-billion-dollar music entertainment facility, The Sphere. These nooses were done as an attempt to intimidate black, indigenous, and people of color, and some displays of nooses mean to intimidate others and place them in fear for their lives. The history of noose displays shows that they are intended to create a pervasive fear in victims. These types of displays can be criminalized under Virginia versus Black as long as legislators are careful to include, which I believe this bill has, intent to intimidate language in their laws. Now, anyone who knows our national leader, Reverend Al Sharpton, knows we have a policy of free speech. Under the rationale of the U.S. Supreme Court's cross-burning decision in Virginia versus Black, 2003, in which the court ruled that a state could criminalize cross-burning carried out with the intent of intimidating any person or groups of persons. The justices reasoned that cross-burning intended to intimidate and constitute true threats unprotected by the First Amendment. In her majority opinion in Virginia versus Black, Justice Sandra Day O'Connor defined true threats as those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. She noted that the history of cross-burning in this country showed that cross-burning is often intimidating, intended to create fear in victims that are the target of violence. But the First Amendment does not protect all forms of speech. Let me say that again. The First Amendment does not protect all forms of speech. U.S. Supreme Court Justice Oliver Wendell Holmes famously expressed this principle in his fire in a theater analogy in 1919. He said the most stringent protection of free speech would not protect a man and falsely shouting fire in a theater and causing a panic. We're not asking for prosecutors to throw charges up against the wall in this bill and hope that they stick. We're asking them to show the noose or the swastika was not put up as a piece of art, but as a form of intimidation. Bias incidents are designed to intimidate the victim and members of the victim's community, leaving them feeling isolated, vulnerable, and unprotected by the law. A failure to address this unique type of crime could cause an isolated incident to explode into a widespread community tension. As a young boy, growing up in Las Vegas, one of the first descriptions that I learned about Las Vegas is that it was termed Mississippi of the West. That is a term that people still use to this day to describe our great city. It's time for us to show the country that the term no longer applies to our great city or state. Enacting this bill throws dung in the face of those who want to see this state be stuck in a time warp. Reverend Dr. Martin Luther King said, "We will remember not the words of our enemies, but the silence of our friends." Let me say it like this. Please don't come to us for our vote and then not speak about our needs when you're on center stage. We need all of the legislators who believe that racism and intimidation by race is a crime to step forward and to support this bill. We need SB 227 to become law. Thank you, Senator Pat Spearman, for carrying this very important bill, and thank you, committee, for your time and your attention.
Thank you. Madam Chair and committee members, I'd like to read to you a couple of proposed amendments. To add language intended to clarify that for the purpose of prohibition prescribed by Section 1 of the bill, the term Nazi swastika means the official emblem of the Nazi Party and does not include any ancient swastika symbols that are associated with Hinduism and Buddhism. Number 2, to remove the provisions in Section 1 of the bill which prohibit a person from placing or displaying a symbol of hate on public property or in plain view of the public, with provisions which instead prohibit such conduct specifically on the property of a school, college campus, place of worship, cemetery, or place of employment. And I just had a meeting about an hour and a half ago with the ACLU and the public defenders and several other people, and so there is an additional amendment coming that will make sure that the language in this bill, all of it, is constitutionally permitted. We don't have that yet, but we will have it soon, and as soon as we get it, you will have it as well. So with that, I will stand for questions.
All right, questions from members of the committee. Senator Nguyen.
Thank you. I have a couple of questions when we're referring to the juvenile section. And I kind of know the answer to this, but I'm just hoping that you might be able to put it on the record for the other committee members. I know that there's a lot of specific provisions that are included in here, including taking away a driver's license. Are you familiar with any other sections that deal with juvenile offenses where they also take away driver's license?
For the record, I'm Senator Pat Spearman. I represent Senate District 1, and in the bill, I'm not familiar with that, but what I do know is that there is a law here in Nevada that requires students to achieve and maintain a certain grade point average and make sure they're not skipping classes at school, and if they do that, then they're denied the privilege of getting a driver's license. So that's a question that I don't know the answer to, but
I know I'm familiar with truancy and firearms and graffiti and DUIs for juveniles where they lose their license ability. There may be others, and I'm sure legal might be able to answer that question for us at another time. But in addition to that, and this may be another question for legal, there are obviously prescribed like other penalties in addition to the driver's license, in particular the class. Which I'm happy that there are. I think we should treat children differently. I think they are learning, and this could be a potential learning experience for them. Do you know if that is also something that specific types of punishment are prescribed in statute for other juvenile, like I guess, delinquent acts.
So again, Senator Pat Spearman representing Senate District 1, and unfortunately, I do not know that throughout the entire statute. But I will say this, that one of the things that we discussed was making sure that those who perpetrated this type of hate crime got the message that in Nevada, we don't want that and we won't tolerate that. So I know that there are other things in statute that deal with juveniles, but unfortunately, I was a poli-sci major, not a legal major, so.
Chair, may I ask another question? I do have a question also about the amendment or the proposed conceptual amendment number 2 regarding places that it is prohibited. I'm assuming that you wanted to have a little bit more specificity, and that's why you. So is it my reading, or do you feel like this potentially is covered in other like criminal statutes? So if someone was to put a noose on your neighbor, like a neighbor's like yard, that wouldn't be covered under this any longer. Is that correct?
Yeah. Senator Pat Spearman for Senate District 1, yes, that's correct. And the amendments that you see are a result of several different meetings with several different community groups and legal experts, if you will, as well as our own LCB, to make sure that it was tight enough so that someone didn't misuse this statute to try to arrest or do something to a young person who had the constitutional right to protest, if you will. And so we needed to make sure that it was tight, which is why we've got some other language coming. Wanted to make sure that this was done with great specificity so people would understand exactly what the intent is and what we expect in the future.
Thank you. That's all.
Senator Dondero Loop.
Thank you very much, Madam Chair. So I have a couple questions and clarification on the same thing with Section 10. And I've said this before on the record, you know, we have less kids driving nowadays, of course. They can take an Uber anywhere. I remember hearing some bill, well, you know, if you live in Spring Creek, Nevada, and you're going to Elko, you're not just jumping on a city bus to go there for work. And what I always worry about is that we have these stipulations that take things away from kids, which gives them, they're not working. Maybe that's how they get to school because their parents aren't around. I don't know. And then and I'm not suggesting that they shouldn't be punished. I'm just saying when we take these things away from kids, we allow them to not have the same responsibilities, and now what are they doing is my concern. Because I don't see that we have anything that we do that, while it says a child to participate in a program designed for prejudice and promote empathy and respect for diversity, I'm not sure I see any stipulations that require them to do that. So I was just kind of wondering, you know, how those two things fit. And as I said, it's just a question because I think sometimes we isolate things to kids being in a city, right? Being in Reno, being in Las Vegas. And we have to remember that kids are, first of all over our state. And sure, maybe in Hawthorne they could walk to school. But like I said, if they're not going to work, and maybe they're not getting to school every day or not going to their sports events or whatever it is, because they can't get there, and it's whether they drive or a friend of theirs drives, I don't know. Now we've got them with more and more discretionary time. So I'm just like wondering where we're going with that and if there's any idea about programs to help them with these things.
Thank you. Madam Chair, through you to Senator Dondero Loop, I would direct your attention to Section 10 and 2 or 3 on page 13 of the bill. If the juvenile court finds that the suspension or delay in the issuance of the driver's license of a child pursuant to this section would cause or is causing severe or undue hardship to the child or his or her immediate family, and that child is otherwise eligible to receive a driver's license, the juvenile court may order the Department of Motor Vehicles to issue a restricted driver's license to the child pursuant to that. And so the whole idea was to make sure that there was available to the courts if they are found guilty of that, but it's available to the courts. That's not my decision to make. That would be the judge's decision to make. And I'm sure that based upon what we have here in the law, that they would take that into consideration. Additionally, when I spoke with ACLU and the public defenders this morning, there were some issues that they had with respect to the language, and we're working on tightening that up. But I do understand your concerns.
Thank you very much. I mean, I had one of my own children didn't even drive until she was 17, didn't want to drive. And I find that more and more as kids today have other options. But what kind of programs are available to these youth who may experience this?
Thank you. I'm going to direct that to Reverend Bush, because I do know that there are programs available that are already in use by the Southern Poverty Law Center. So Reverend Bush, and I know that 1865 is doing some of those programs already. So with your permission, Madam Chair.
Thank you very much,
Yes,
Reverend
ma'am.
Bush.
Yes, ma'am. With your permission, I would love to defer this to the co-founder of 1865, who is here in the room with me to answer that question. Please welcome Jonte Marshall.
Good afternoon, Jonte Marshall, co-founder of 1865 No Racism in Schools, for the record. In response to your question, the Center for Racial Justice, Teaching Tolerance, Southern Poverty Law Center, and many others are dedicated to teaching racial sensitivity training for all ages.
Thank you very much, and I am absolutely aware of your group and have followed your good work. Senator Spearman, is there something in here? Forgive me if I've missed it, but is there something in here that directs kids to that direction, or is that a judge-ordered piece?
For the record, I'm Senator Pat Spearman, representing Senate District 1, and that's up to the courts.
Okay, thank you very much, and thank you, Madam Chair, for your indulgence. I just want to make sure that we're not disciplining kids, if you will, without teaching them why, right? We need to teach them and give them information as to why this is wrong, or the consequences fall upon deaf ears sometimes. So thank you very much.
Thank you, Senator Spearman, representing Senate District 1, for the record, and I agree with you, Senator Dondero Loop. There are programs similar to this in the adult world when people are directed to go to anger management, to AA or NA, or those sorts of things, and you are absolutely correct. It would be wonderful if we could mandate that the parents attend that with them, because, as I said at the beginning, hate is learned. They're not born with it, but it's learned. It's a learned behavior. So thank you.
Other questions from members of the committee? Senator Stone.
Thank you, Madam Chair. I do have some questions, but a few introductory comments if I can. First, I'd like to say that I think your childhood and the racism that you experience is horrific, and I appreciate your testimony today, Senator Spearman and Mr. Malin and the Reverend. I appreciate your perspectives on this bill. I also want to report that my family has also been a victim of hate crimes, the likes of which have never been seen in the world in the past 85 years. 25% of my family, my great-great-grandparents, my great-uncles, great-aunts, my cousins that were children, 25% of my family were not only the victims of hate crimes, but they were marched into the ovens and the gas chambers of Auschwitz. They're gone. I never got a chance to meet that part of my family. So do I hate what the swastika represents today? 100% yes, I hate what it represents. And while I believe that our First Amendment rights are not absolute, and we heard that Oliver Wendell Holmes, a former Supreme Court justice, made that very clear, it is a right that's enshrined in our Constitution, that's been fought for by millions of Americans that have given the ultimate sacrifice to ensure the same, and that free speech must be protected even if we don't like the message. Where hate speech is coupled with violence, that is the exception. throw the books at the perpetrators, put them in jail for as long as you possibly can. My concern in this bill is the definition of the symbol of hate. I think it's too subjective. I think it's too broad. And likewise, in the bill, the definition of intimidation is vague and subjective and needs to be defined. And I'd like to give you some examples, and these are going to be some of the questions, Senator, that I'd like you to kind of respond to. So if I, Jeff Stone, I wear a United States flag lapel pin on my suit, am I offending a group that relate to Colin Kaepernick, that feels that the U.S. flag may represent racism and oppression? And can I be sued if I repeatedly go to an event where that American flag is displayed on my lapel pin? If I wear an Israeli lapel pin, being proud of my Jewish heritage, will this anger some Palestinians that think that the alleged apartheid issues of Israel is offensive? And can they in fact sue me? If one proudly wears the pride flag, can a religious person sue if they feel that they're being intimidated by their constant meeting with this person? I don't know if you're aware, but some NFL players refuse to wear a pride jersey during warm-ups. Can they be sued for not wearing the pride warm-up jackets or suits? The number 88, for those of you that don't know, it's the 8th letter of the alphabet H, which is a hateful number as it refers to Heil Hitler. But we have an existing market that's called the 88 Ranch. Can they be sued because they may be allegedly Nazi-related? Bubba Wallace, as you know, is a top African-American NASCAR driver that was assigned a garage to park his stock car. And there was something described as a noose in his garage that they thought might have been a racist symbol for him. And yet the FBI later concluded that all the garages had these basically pull ropes to pull the garage open and closed. Could he have been, or could NASCAR or the owner of the racetrack been sued under this bill, even fueling more racial tensions? In Section 1, number 5, lines 25 through 27, nothing in this section shall be construed to prohibit a person from engaging in any constitutionally protected exercise of speech. Yet, in my view, it seems to just do that. And we all, Madam Senator, take an oath to protect and defend the Constitution, whether we like what the Constitution says or not. The bill chips at our rights protected under the Constitution, where one day a political sign of an opponent may trigger intimidation by a party filing a lawsuit to quell that free speech. So these rights, I think, are very important to me and to other people, and chipping away at them, I call it death by 100 slices. Are we going to find ourselves in America where we just can't say what we want to say because we fear it's going to offend somebody?
Thank you, Madam Chair, through you to Senator Stone. And I appreciate that. And I'm so glad that you started off by saying there are several Americans who have served and some who have paid the ultimate sacrifice. And for 29 years, I served in the U.S. Army and defended anyone's right of free speech. The examples that you have given are examples of recent, quote, history, if you will. Let me deal with Colin Kaepernick. I really didn't understand why people took offense at that, him kneeling during the Star-Spangled Banner. Don't know why. Because you know what? I have participated in memorial services for soldiers and airmen and other service members who have been killed in combat. And guess what we do? We kneel as a sign of respect. As an ordained minister, other than times when I pray in public, I usually kneel. So I didn't understand that. You talk about the American flag and, maybe it's offensive to people. It may be, but I don't know that we classify that as hate speech, and that's one of the things that we're dealing with in the amendment. And for those who have never experienced the kind of vitriol and hatred, I feel for your parents, because at one time when I was in Germany, guess where we were based? We were based in one of the former concentration camps. And one of the things that I and the people in my company couldn't figure out was why the smell was coming at us like that. Whenever we turned on the hot water, there was this putrid smell, and we couldn't figure it out. And the very last day, before we got on the buses to go back to come back to camp, we were told that this was a former concentration camp. And we were asked to look around, and what we thought were mounds of dirt were actually mounds with human remains in them. I am acutely aware of those types of things. And unfortunately, when we start talking about these symbols of hate, that really the symbols themselves were neutral until they were co-opted by hate groups. And it is the co-opting of those hate groups that has made those symbols what they are today in terms of hate speech. And so we're gonna tighten up the language, but many of the examples that you just gave, the United States flag, I don't know that anybody who would be offended by that. I mean, it's our flag. When we stop and we think about what someone's free speech could be, you know what comes to mind is the absolute horror and nauseating feeling I got as I saw people attacking the Capitol on January the 6th, talking about this is America. That ain't America. It wasn't America. And the years that I served in the military, and the friends of mine that are buried in Arlington National Cemetery or someplace else, that's not what we served for either. But it had been bastardized so that people who want to hate and people who want to justify that hate would co-opt something like the American flag. And so we're going to tighten up the language. But when you start talking about offense, there's a difference between offending and then putting forth a symbol that historically has been used to say, do this and this is what happens to you. Do this and this is what happens to you. I was in Richmond, in Petersburg, Virginia, just before I was commissioned, and I'm running to do my PT. And you know what happened to me? I'm on a public road, and a group of white guys in a pickup truck passed by me and started yelling some very offensive names. And they turned around and they came back and they began to tell me what they would do to me sexually if they could catch me. They went back that way and up the other way, and you know what I did? I found a ditch and I belly crawled for about 4 blocks through dirt and through stickers and thicket and muddy water until I got close enough to my sister's house that I could get out of that ditch and go to her house. Now, the words that they said, they're in the dictionary. They're in the dictionary. But I was very clear about what they meant. And I didn't need someone to tell me, oh, that's hate speech. I didn't need that because I had experienced it enough. When I was in Alabama, I didn't tell you that my life was threatened. It was threatened, and it was threatened because I wouldn't let people call me the N-word. I've been there, I've done that, I know what it looks like, and I know what it smells like. We are defining in this bill what real hate speech is about. And there are folks who have experienced that who are very clear when someone says something, what it means. Dr. King was an ordained minister and a pastor. But when they burned a cross in his front yard, he knew exactly what that meant. Exactly what that meant. And I think historically, those of us who have experienced it in real life and didn't read about it, we know. Yeah, we know.
As one follow-up, and thank you for your stories, I have similar stories being one of the few Jewish kids in my entire school system. And I remember my dad sitting me down one day and explaining to me that we were Jewish and that not everybody likes Jewish people, and that you may be picked on, you may be kicked, you may be hit, and you need to walk away if somebody is calling you names like a kike. I was called a kike on numerous occasions during school. It's the only times I ever got into fights when I was in high school. It wasn't because I picked the fight because somebody called me a kike, because my father taught me to walk away. You've heard the old saying, sticks and stones may break my bones, but names will never hurt me. My dad told me always try to walk away. But if somebody strikes you or throws something at you, you are to defend yourself. And I did defend myself. Not only against one person, not only against two people, but sometimes three people. Sometimes I won, and sometimes I lost. And those students should have been reprimanded. Those students should have been arrested by police. I don't believe that they ever were. But so we share some very commonalities in our history. I just want to make sure that the terms that you use in your bill, especially symbol of hate, I hope that you will narrow that definition and that you will narrow the definition of intimidation to make sure that symbols that we believe today are non-controversial, that could be controversial tomorrow, are not going to get somebody innocently arrested with a felony for exemplifying or portraying their constitutional rights of expression. So I appreciate what you're trying to accomplish here today. I just hope the bill can be improved to accomplish what you're trying to do. Thank you.
Senator Scheibel. Elliot Mallon for the record. Senator Stone, well, through you, Chair, to Senator Stone.
You can go direct.
Thank you. You know, I had those same experiences. In high school, I had somebody tell me that I needed to go take a shower. They didn't mean that I was dirty. They meant that I needed to go be killed for being Jewish. In high school, I had another student tell me, hey, you need to go read Mein Kampf. For those that don't know what Mein Kampf is, and I hope you do, it was Hitler's manifesto on how he got to where he was with his anti-Semitism. It stemmed from the protocols of the Elders of Zion. To this day, in this state, we have people here who preach those protocols. It is a very rampant problem. I want to mention something really fast on all of that. The ADL's audit on anti-Semitism was just released. This audit has been compiled annually since 1979. Our finding this year that there was a 36% increase of anti-Semitism, and Nevada is not immune to that. It was only just about a year ago that Colleyville happened. So I understand exactly what you're saying. I empathize with that because I've lived it as well. And I am committed to working with the senator and making sure with those partners that we tighten up that language as you're talking about. So I appreciate it. Thank you.
Other questions from members of the committee? Senator Hansen.
Thanks, Madam Chair. Got a bunch, actually. It's been interesting to see the evolution of this in my lifetime. I remember when the ACLU defended the right of the Nazi Party to march in Skokie, Illinois, which is a predominantly Jewish neighborhood. That was the American Civil Liberties Union, perhaps a majority of which were Jewish. In fact, one of them, Noam Chomsky. And I always remember his quote, if you believe in freedom of speech, you believe in freedom of speech for views you don't like. Goebbels was in favor of freedom of speech for views he liked. So was Stalin. If you're in favor of freedom of speech, that means you're in favor of freedom of speech precisely for views you despise. Now, he's Jewish. He was a member of the ACLU. And their defense obviously was not because they believed in Nazism, but because they recognized that in America, we have a right to for people to have free speech, including the right to march in certain areas for views that they absolutely hated because it's protected by the First Amendment. The comment that Colin Kaepernick was actually kneeling out of respect for the American flag, I'm sorry, that's absolute nonsense. He was not doing that. In fact, to Colin Kaepernick, the American flag is a symbol of slavery, which is true. When slavery existed in the United States, it was under that flag. Jim Crow, segregation, all of the issues that we've been addressing all occurred under the American flag, which still exists right now and which we all take a pledge of allegiance to every day in the thing. So the idea that that could not be considered a symbol of hate is painfully inaccurate. My question is this. As I read the bill, there's a ton of vagueness in it. For example, if somebody puts up a sign, let's say I put up a sign saying marriage is only between a man and a woman. Would that be considered something that would intimidate somebody or cause a person to feel threatened or intimidated? And then if somebody came to me and tore down that sign or threatened to tear down that sign, would that be retaliation against me for exercising a right that is actually a constitutional right? then the whole idea of symbol of hate, I agree completely with my colleague. That is so vague. Any symbol, image, or object that expresses animus, extremely vague. So I just see this whole bill. I understand the intent. I am deeply sorry for what you had happen to you growing up in the Deep South, especially, or Mr. Malin and for his experiences with anti-Semitism. I mean, but the bill itself goes way beyond just nooses or swastikas. And I think that's something that needs to be addressed. The last thought, especially for Mr. Malin, since he and I are friends, there is a significant movement among the American Jewish community about what's a correct role in Israel, because Israel is officially defined by the Palestinian movement especially as an apartheid state. And so if nobody answered the question, if somebody is wearing a pro-Israeli flag and somebody is of the descent of the Palestinian way of looking at that whole Middle East situation, could that not be considered a symbol of hate as well?
Elliot Mallon, for the record. Senator Hansen, I appreciate the question. And I think it's a good question. And I think that we've addressed a little bit of this is we're working on tightening up this language together with a coalition of partners to make sure we protect First Amendment liberties for everybody, and we make sure we define what we're trying to do here. While I will say this, and you know this, we are friends. I have lived in Israel. I am a Zionist. That doesn't mean that I look at the Palestinian flag as a symbol of hate either. Palestinian Americans have a right to display that flag, as do Israeli Americans to display the Israeli flag, as Jewish Americans do, as anybody of a national heritage outside of the United States does for their national heritage. And so we are continuing to have those conversations. But there's also definitions that things must meet. When we talk about apartheid, and that is not what this bill is about, there are definitions for apartheid because some say apartheid does not mean that's what that is. And so we have to have legitimate discourse about that. And this bill in no way takes us away or strips that ability for us to do that. So thank you.
But it does say intent to cause a person to feel threatened or intimidated. Just feel, And obviously I would think that either an Israeli American supporter of Israel like yourself or Palestinian on either side of that could very easily say, I feel intimidated by the fact that you are so pro-Israeli or you are so pro-Palestinian. Would that not, under that definition of law, be something I could pursue as an example of intimidation?
Chair Elliot Mallon, for the record. The way I read this bill right now, and again, there are ongoing conversations for an amendment to fix a lot of these concerns that you are raising, it's the intent to intimidate. Because I wear something does not mean I intend to intimidate either.
And last question on this. There have been a series of faked hate crimes where people who put up nooses or swastikas, in fact, were black people that put up swastikas or KKK symbols or whatever. That happens. Is there a punishment factor for the abuse of basically they got the whole country stirred up thinking there was this horrible situation, and then when the cops actually do the investigation, it turns out that it was an internal thing by somebody painting KKK or swastikas or whatever on something. Is there a way to punish people that abuse that privilege?
Go ahead.
I think that there is, and I think that's already codified in law. If you make a false claim and they find out that it's a false claim, it's already codified in law. Let me address something. I did not say that Colin Kaepernick was disrespecting the flag. I said him kneeling. And for me, as a veteran, I had no problem with him kneeling. A lot of people did. You know what was really, really funny about that? Is some of the same people who had a problem with him kneeling in protest were some of the same people who had no problem whatsoever perpetrating racism. So, I get it. And do they have a freedom of speech? Yeah, they got freedom of speech. They can do whatever they want to do, okay? What this bill is designed to do is to address
Just
something.
No, Senator, we're on the same page on that. Colin Kaepernick had every right to kneel and
understand
oppose
that.
it. And the same people like myself support his rights to actually exercise a constitutional right of free speech, and he did. I'm just saying for the people that are on the opposite side of that, I see this drift in this bill saying essentially, if you support the American flag, in some cases, you could even be intimidating somebody. Or even something as simple as the example I gave of me putting up a sign that says, I believe marriage is between a man and a woman, never between same sexes. That could be considered an act of intimidation or threatening or made somebody feel uncomfortable at the very least.
And I agree with you. I'm black, I'm a woman, and I'm a member of the LGBTQ community. And as I've said on many occasions, you have to be Donald Duck to be more marginalized. And when I introduced the marriage equality bill, I was attacked. I wasn't intimidated because I've been through that stuff before. I've been through it, and now I got steel on. And so every time I see it, that's when I fight. But I'm not intimidated by it. This bill has nothing to do with that. This bill has everything to do, especially with the things that have happened recently. And if we don't stop it and shut it down, it's going to continue to happen. I will read again for the committee's hearing.
Madam Chair, Senators, but before you do that, you got to understand, we're on the same page. I feel intimidated now when I suggest my traditional views on marriage. There are people in this audience that are openly hostile to that and very much upset by my views and regard that as, in effect, being intimidated and even threatening to people who view marriages between the same sex as perfectly acceptable. And the Supreme Court has said so. But that doesn't change my right to say it. So I want to make sure we both understand that intimidation can go more than one direction.
I get it. Let me read for the committee's hearing again. Number 2, the conceptual amendment. Remove the provisions in Section 1 of the bill which prohibit a person from placing or displaying symbol of hate, public property, or in plain view on the property of school, and it specifically deals with the property on school, college campuses, a place of worship, a cemetery, or place of employment. And I believe I read this one as well. We are also working, because I just met with these groups about 11 o'clock, 11:15 today. We've been working on this all along, but our last meeting was about 11:15 today. Working with ACLU, Anti-Defamation League, NAACP, public defenders, and other social justice organizations to develop language on this bill to ensure its constitutionality. One of the reasons we have conceptual amendments is to make sure that we tighten it up and so that there is no misunderstanding.
Well, thank you, Senator Spearman. Madam Chair, I think I've used more than my fair share of the time. Thank you very much. I look forward to seeing the amended version. Thank you.
All right, any other questions from members? I don't see any, so I just want to ask a question, bring something up. In getting ready for this hearing, I was trying to grapple with some of the questions that have been raised about the specificity of the bill, and please tell me if I'm wrong. My understanding is that we're trying to use the term symbol of hate as a legal term. And I think maybe part of the issue is that we don't have a definition of a symbol of hate in the bill that is meeting a constitutional standard. I'm looking specifically at Virginia v. Black, where the Supreme Court upheld Virginia's law outlawing the burning of crosses with the intent to intimidate somebody. And they specifically said that the reason that the Virginia legislature could ban burning crosses is because this is quote, in light of cross burning's long and pernicious history as a signal of impending violence. And so is the intent of the bill to follow the ruling of the Supreme Court in Virginia v. Black and ban symbols of hate that have long and pernicious histories as signals of impending violence?
Thank you, Madam Chair. And that indeed is the intent, which is why we continue to work on the bill. We're working on the bill with our staff at LCB and also other partners to make sure that the intent of the bill is clear, so that there's no ambiguity, so that no one can twist it and say that if that is true, then this is true. So yeah, that's it. That's the intent of the bill.
Okay, thank you. Were there other questions? Okay, there were not. Sorry. And so with that, thank you for your presentation. We will move on to 20 minutes of testimony in support. If you want to give testimony in support, please go ahead and make your way to the table here in Carson City or down south in Las Vegas. We will start with in-person testimony in Carson City. You'll each have 2 minutes. Please go ahead whenever you're ready.
Good afternoon, Alexander Marks with the Nevada State Education Association, speaking in support of Senate Bill 227. NSEA works tirelessly to dismantle systems of oppression to advance racial and social justice for our members and our students. I'm a Jewish man. I grew up hearing about stories from my grandmother about seeing signs that stated no Jews or dogs at the pool, hearing about swastikas carved into students, and even knowing cousins whose parents met in concentration camps. We are not that far removed from 1920. Throughout my life, I've experienced anti-Semitism in various forms similar to my colleague Elliot. The last 5 to 6 years have been quite scary to be a Jewish person in America. We've seen the growth of anti-Semitism across the U.S., fueled by a more brazen white supremacy movement, no longer content with hiding behind their hoods. Anti-Semitism exists, and it has a symbol. Things mean what they mean, and SB 277 seems to understand that. With this country's history, the noose has always meant much more than a knot in a rope. It's a reminder of America's dark history of racial violence. This was a tool to kill people. It is by its very nature seen as a threat. I've experienced this throughout my life. Some people who love to point out that swastikas existed long before the 1920s. However, we all know what that symbol means to this day, and we know why people are using it. Intent matters, and we know why people are using it. Never in my life have I experienced a situation where someone has said the word swastika and someone has asked, do you mean the Nazi swastika, for clarification. White supremacists are not using Buddhist swastikas to intimidate outside of synagogues or on school lockers. This bill and the amendment, I believe, makes that clear. These symbols have hate meanings that won't go away. They exist forever, and I doubt we will ever see the day where a Jewish person like myself will ever see a swastika as anything but a symbol of hate and intimidation. When racism and anti-Semitism occur, we all bear the responsibility to decry it and work to remove it. In its efforts of social and racial justice, NSEA simply stands on the side that hate is hate, and not using these symbols to intimidate or at all would be the best path forward for our students and society. This is a bill worthwhile. Worthwhile endeavor, and I urge your support. Thank you.
Good afternoon, Madam Chair and members of the committee. My name is Marlene Lockard, and I'm representing SEIU 1107. Legislation against hate symbols like swastikas and nooses is necessary to promote inclusivity, respect, and safety within a community. These symbols carry a history of violence and oppression, and their display can create a hostile environment for individuals who are targeted by them. Such legislation sends a clear message that hate and discrimination will not be tolerated, and it can help prevent acts of hatred and violence. By prohibiting these symbols, we work towards creating a more equitable and just society where everyone feels valued and protected. Thank you.
Madam Chair and members of the committee, for the record, my name is Annette Magnus, and I'm here today in support of this bill. I went back and forth with my team over the last few hours about this bill, and I talked to my sister Jay, who is down in Las Vegas, and I feel strongly that despite the concerns with this bill that I know that the amendment will address, this is an important bill. I have seen the harm that these images have caused Jay and Akiko, who work with 1865 No Racism in Schools. I often am the one who gets the phone call from Akiko when these types of things happen, and I know the pain that it puts them through every single time this happens. And so we are here as an organization in support of this bill because we know the harm that hate speech and hate has caused in our communities. We saw it yesterday with the mass shooting, and we continue to see it every day. And so I feel strongly that this bill is important, and we need to start to address this head on. Thank you.
All right, I don't see anybody else coming to the table in Carson City, so we'll go down to Las Vegas. Please go ahead.
Jante Marshall, co-founder of 1865 No Racism in Schools, chair of Anti-Racism for National Action Network. I am in support of this bill. As an impacted person, I firsthand have been in receipt of hate signs and symbols specifically intended to intimidate myself, our children, and our allies when responding to racism acted upon by supremacists of all ages in our community as recent as 2021. Hail Hitler signs, Confederate flags, Nazi swastikas, and KKK Klansmen in full garb are all things we consistently encountered by adults and children, encouraged by their parents who are in opposition of our work in anti-racism during public meetings, school board meetings, school settings and campuses, and common spaces. None of these behaviors have ever resulted in any consequences, rather protected and emboldened by leaders and officials in public service over the last 4 years. Furthermore, we continue to fight for protection from hate symbolism in public workspaces as we receive complaints of nooses on construction sites and on public property. In 2023, symbols of hate or the tolerance of its presence should not be tolerated in our state. It is our duty to interrupt, disrupt, and dismantle racism in every way with aggression. Words do not hurt, but we will no longer walk away from them. I have heard comments over and over about these symbols being protected by freedom of speech. Yet freedom of speech is intended to protect those in the press, the assembly, and the right to petition the government. However, when you go and you reference the true definition of symbol of hate, it means a symbol, image, or object that expresses animus on the basis of race, color, religion, gender identity, sexual orientation, disability, or national origin. It includes the noose, it includes the Nazi swastika, and it absolutely includes the Confederate flag. In addition to that, I want to express that according to the Webster Dictionary, speech is defined as the communication or expression of thoughts in spoken words. If the words are not spoken, why should we protect them? Thank you for your time.
To the chair and to, again, the Senate committee, my name is Bishop Derek, D-E-R-E-K, Rimson, R-I-M-S-O-N. I am the chair for NAACP as well as the religious advisor for the National Action Network. Of course, we are standing strong with support of this bill. We want to thank Senator Pat Spearman for garnering this bill. And of course, I think that it is vitally important that we really understand. We understand 400 years of pain for the Black people. And of course, these symbols, these signs of hatred, they must go, they must stop. If you really understand, our race is the only race in America that had to evolve. We've went from the N-word to the Negro to the colored to becoming Afro-American and then African-American until finally we found a brand of being Black or people of color. So our race is the only race that have evolved over 400 years. We're tired of the oppression. We're tired of these types of hatred and these types of symbols being hidden as just forspoken, being hidden behind free speech. So we support this bill. We stand behind this bill, and I'm hoping that you, the Senate committee, will push this bill and advance this bill. It is necessary. It is needed for the Black community, as well as for the Jewish community, as well as for the LGBT community. We need to bring this to an end. Thank you.
All right, I don't see anybody else coming to the table to testify in person in Las Vegas, so we will go to the phones for testimony in support of SB 227.
Thank you, Chair. If you would like to provide some public comment, please press *9 to take your place in the queue.
My name is Jerry Burton. It's Jeriburton, and I'm the co-executive director of the Nevada chapter of the National Organization for Women, and I'm calling in strong support of SB 227. We want to thank Senator Spearman for presenting this anti-hate crime bill. Nevada now stands up against hate and intimidation, and this will protect our communities from symbols of terror. Nazi swastikas and nooses are universally recognized symbols of hate and violence and cannot be tolerated, and we need this passed in Nevada, and we hope you'll support SB 227. Thank you.
Good afternoon. My name is Camila Bywater, president of the Las Vegas Alliance of Black School Educators, LAVASI for short, and the chair of the Education Committee for the National Action Network Las Vegas chapter. I ask that you take one moment to think about the experiences of Black people who are descendants of slaves. Think about that terror and violence that happened during the transatlantic slave period. Think about the postcards that were sent to attend a barbecue. And I'm not talking about eating chicken and corn at the park. I'm talking about going to a barbecue to experience Black people being hung by trees. That is a tragedy and a connection to horror and violence that we as Black people are asking you to help us not experience in this state and around this country. We're asking that you take into consideration that the work that has gone into this bill. We thank Senator Spearman for her time for this. Not only do we have to fight against symbols that portray hate, we are literally going back and forth with schools in our state to ask them not to use the N-word in their so-called historical and classical literature towards students. We are asking that you please honor our wishes today. Thank you for the chair and the committee members for hearing this bill. We hope that you would just take one day to experience life as a Black person here in America. Thank you so much for your time.
Once again, if you would like to testify in support of SB 227, please press star 9 to take your place in the queue. There seem to be no more callers at this time, Chair.
All right, thank you so much. We will move now to 20 minutes of opposition testimony. If you wish to give testimony in opposition in person, please go ahead and make your way to the table in Las Vegas or Carson City. You'll each have 2 minutes. Go ahead when you're ready.
My name is Terry Graff Polvino, Reno resident, and I certainly understand the proposed issue of the swastika and noose, which are horrific. But I also want to make sure that, in line with what Senator Hansen said, that this cannot be expanded to other symbols that do not carry the same weight of hate. And I'm reminded of what Martin Luther King said, and this I have on my computer. He chooses love because hate is too big a burden to bear. So I think that that's something that we need to keep in mind. I hear the names of the organizations that are working to help amend this bill. I didn't hear the name of any Christian organizations, a little more. So I would like to see that added to the analysis. Also, other symbols could be converted to negative intimidation, or however you're going to describe it. But I think we need to focus on the ones that we see that are causing the most pain and hate, the ones we're targeting here. And the amendment talks about church properties. What about if somebody puts a nativity scene on a church property? Is that going to hurt somebody's feelings who doesn't believe in Christmas, who believes in something else? Are we going to be sued? So I think that you have to be very, very, very specific in what exactly are the issues that are going to be litigated and are called intimidation. Thank you.
My name is Ken Pulvino, Pulvino. I'm a resident of Reno. First, my net on this whole topic is I don't think this law is necessary. I think that existing laws and existing ways of dealing with this problem are already in place. I think it's overreach and another example of government trying to define and dictate behavior that is unnecessary. As a preface, coming into this building reminded me, I served as a editor-writer on the editorial staff of the Speaker of the Assembly in New York State. I was also brought there by the state Democratic chairman, and I was in a patronage position, so I used to sit into meetings and then write speeches and all kinds of things for my assemblymen. And I was also in the meetings when the political operatives had input into what the laws were going to be enacted and not enacted. This is unnecessary. The whole idea of going back in history 400 years, the history of slavery goes back thousands of years. And the history of intimidation and bias goes back thousands of years. I'll go back in my history. I grew up in a white Anglo-Saxon Protestant neighborhood as a Sicilian. And I remember one day I was sitting in the classroom and a person behind me said, "Gee, Sicily is just a short swim from Africa." And that was meant to be an insult to me. Luckily, I was brought up in a family where my father would have put me on the ground if I said anything like that. So it wasn't a case with me. But following that, I said to my father, "You know, Dad, all these Americanos, they feel superior." My father, World War II veteran in a PT boat in the Pacific, fought alongside blacks and whites. He grabbed me by my collar and he said, "You're not an Italian American, you're an American. And that comes before all other things. And don't ever let me hear you say that again. You're an American. You're going too far in terms of intimidation."
And that's 2 minutes.
That's it?
That's it.
Okay.
Thank you.
Thank you. Bye-bye.
Good afternoon, Madam Chairman, members of the committee. I'm the state chairman of the Independent American Party. I come from a heritage in which basic constitutional rights, including freedom of religion and speech, were violated by the government. In October of 1838, Governor Boggs of Missouri issued an extermination order and forced the members of the Church of Jesus Christ of Latter-day Saints to leave Missouri in the dead of winter or be exterminated. I myself was arrested while circulating a legal petition in Reno at the bus depot, handcuffed and hauled off to jail in a paddy wagon. The ACLU served as my attorneys in the municipal court where the charges were dropped. My brother, an attorney, took our case to the district and Supreme Courts in Nevada, where I was exonerated. I have been picketed at my office, received numerous death threats and threats to my children. Even in this building, twice, I have had to request the legislative police to walk me out of the building to my car after physical threats to my safety. I am familiar with intimidation. SB 227 specifically states that the symbols of hate are without limitation. That broad interpretation limiting free speech is very dangerous. We condemn hate speech, but we defend the right to utter it. The term intimidate defined as to threaten is very subjective. A true threat is a statement that is a reasonable person would perceive as a threat, threatening them with injury or death. The ACLU, in defending the speech rights of Nazis and KKK members, has reasoned, if we empower the government to censor and silence peoples whose views we find abhorrent, sooner or later that same power will be turned against peoples whose views we find noble. Nadine Strasser, president of ACLU, said, if we don't believe in freedom of expression for those we despise, we don't believe in it at all. Depending upon who holds government power and who is interpreting hate speech, SB 227 could be used to criminalize displaying the American flag, a pro-life, or an NRA bumper sticker, all of which may be offensive and intimidating. The remedy for hate speech is more speech condemning it. Thank you, Madam Chairman.
Hi, Lisa Partee, P-A-R-T-E-E. This bill states that nothing in this section shall be construed to prohibit a person from engaging in any constitutionally protected exercise of free speech. It does exactly that. And to let the girl down in Vegas know, it also protects our freedom of expression as well. This, who determines what is considered hate and intimidation when it's totally subjective? The result of passing this will be to never allow another politician sign in a yard that if it's not the politician you vote for, you'll use the excuse of being offended, scared, and intimidated. The events that Reverend Bush and Spearman and the other gentlemen were discussing were from a long time ago. We've come a long way since then. And the recent incidents they described are rare and isolated. You can't make laws that are repugnant to our Constitution. You can't create laws that are being described as one-sided, such as their testimony and the testimony we've heard today. The gentleman that described anti-Semitic issues at school, while upsetting and unfortunate, these incidents are extremely rare and should be dealt with on a case-by-case basis. We don't need laws in place that are this subjective and open to abuse. Lately, just flying the American flag has become an insult and a symbol of hate to many when it's not anything of the sort. It's those complaining that are the ones filled with the hate and intolerance for anyone else having an opinion. You know, I can't remember seeing a swastika or a hangman's noose anywhere displayed in forever. So using those are examples to push this is disingenuous. You can't force people to feel empathy, and to take these rare occurrences to be so upsetting to you personally as to be intolerant of other people's opinions and thoughts does not require a law. It's something we've all dealt with at some time or another in our lives. I've been discriminated against and called racist names. I've dealt with it. I don't need to have anyone arrested for it. This is about attacking our First Amendment. Remember the oath that you took to protect our Constitution, because this is repugnant to our Constitution and cannot be passed. Thank you.
Casey Rogers for the record. I love coming up here trying to talk and then nobody's looking at me. It's the greatest. First and foremost, I will let you know that I am a widow of a United States soldier who was killed in action in Afghanistan. He fought for the very freedom of speech for everyone, including the 18.2% of blacks, the 18.2% of Hispanics, the 13.1% of the blacks, and the rest of us that are Americans, and that are white, and that are Asian, and all colors. There's the first thing that you have to notice with this is oppression. When you put your hands of freedom of speech in the hands of oligarchs who control what it's going to be and how it's going to be displayed, you're saying, I have to say, is a pride flag going to be offensive? Is that intimidating to somebody? I like the examples that were brought forward. And then the most important thing here is the intent, the word intent that has been used in this whole situation. Men have to be able to be violent. Men have to be able to be intimidating. You want to know why? Because if you're not, then people will roll over you like a Mack truck, kill your family, rape your children, do whatever the heck they want. You have to be able to be intimidating. Don't take that for granted by a symbol that people may not like, but it is our history and it has taught us so much. You have to be able to be intimidated.
Madam Chair and Committee, my name is Lynn Chapman, and I'm the State Vice President of Nevada Families for Freedom. Does the First Amendment protect hate speech? In a Supreme Court case on the issue, Mattal and Tam in 2017, the justices unanimously reaffirmed that there is effectively no hate speech exception to the free speech rights protected by the First Amendment, and that the U.S. government may not discriminate against speech on the basis of a speaker's viewpoint. When the National Socialist Party of America, the Nazis, was declined a permit to march and speak in Chicago, they sought a permit to speak in the city of Skokie, where 1/6 of the population was made up of families that had survived the Holocaust. County authorities attempted to block the Nazi march, citing the city ban on wearing Nazi uniforms and displaying the swastikas. The Seventh Circuit Court of Appeals upheld a lower ruling that the Skokie ban was unconstitutional. The case was appealed to the Supreme Court, where the justices declined to hear the case and allowed the lower court's ruling to become law. What constitutes a symbol of hate? I recently heard that the thumbs up that people give is now a hate thing, but to me and to many other people, it just means something is A-okay. Who determines what the symbol of hate is? And who determines if something's intimidating or not? We have so many different cultures in America today, and every one of them have different meanings to different words, different actions, different symbols, and religious symbols. And I believe that people should treat others with respect, but that does not always happen. I grew up in a black neighborhood, and I was the minority because I was white. I had a lot of things that happened to me as well, but I don't hate people because of it. It was a learning experience, and it's not always fun, I know. But
That's 2 minutes.
Thank you very much.
Thank you.
Good afternoon, Bob Russo for the record. I oppose Senate Bill 227 that violates an individual's right to free speech. I find this bill to be subjective and wide open to various interpretations when it comes to categorizing a symbol of hate. How can anyone know if someone intentionally wishes to intimidate, frighten, or threaten them? A perception of intimidation does not make it a reality or a factual event. We all carry baggage from events that occurred to us during our lives, and the emotional reactions from those events can carry into the present moment and make us perceive a threat that is not there. So how do we deal with these situations in this bill? For example, someone's driving in a pickup truck. They have an NRA sticker in their window. Someone's behind them. They feel threatened. Okay, is that driver going to be guilty of a crime of intimidation when they've really done nothing? Or someone who challenges critical race theory, are they going to be labeled a racist and found guilty of the crime of intimidation simply for expressing a viewpoint? So what kind of a can of worms are we opening up with this bill? Now, there's times that I'm appalled when I see how people verbally attack one another's character online or in heated discussions. Yet I would put my life on the line to protect the right to say what they do. It's unrealistic to pretend that we can protect people from feeling intimidated. What kind of a nation are we creating if we must be continually guarded when we speak or display a sign or flag that expresses a viewpoint because we never know how they will be perceived? Or to live in a nation that censors what we can and cannot say because some find those views distasteful? Is this the America that we want to live in? Please oppose Senate Bill 227. Thank you.
Good afternoon, Joy Trushinsky for the record. I do not support SB 227 as it violates free speech by creating the crime of intimidation. This bill only mentions swastikas and hangman's nooses specifically, but the symbols of hate are without limitation. I find the black fist in the Black Lives Matter flag to be intimidating, especially when BLM during the Summer of Love burned, looted, and attacked the police and MAGA supporters. Likewise, I find the KKK, Ku Klux Klan symbols intimidating, knowing its history of violence and death. Actions always speak louder than words. I believe this is a very dangerous bill because the possibilities of limiting free speech in this bill are endless. I condemn hate speech, but defend the right to utter it. The term intimidate is very subjective and personal and subject to whose interpretation. Censorship is a slippery slope, and silencing people whose views we do not agree with, sooner or later that same power will be turned against people whose views we support. If we don't believe in freedom of expression for everyone, we don't believe in it at all. Please protect freedom of speech. Thank you very much for your time.
Good afternoon, Madam Chair and the members of this committee. I'm Susan Ruth, spelled R-U-C-H for the record. Our country and state believes in the right to freedom of speech. We do condemn hate speech, but SB 227 violates freedom of speech. Article 1 of the Nevada Constitution is entitled Declaration of Rights, Section 9. Every citizen may freely speak, write, and publish his sentiments on all subjects, being responsible, and that's the key word, responsible for the abuse of that right, and no law shall be passed to restrain or abridge the liberty of speech of the press. The definition of intimidate can be subjective by whoever is defining that word. If this law is passed, at some point, the law could circle back and attach the freedoms from the people who passed this legislation. In 2020, when Black Lives Matter was protesting in Carson, I was approached by people and I was intimidated by them, and I was called a very derogatory names. But I did not, I walked away. I didn't feel that I needed to go get the police. I just let it go. So, I have experienced, we've all experienced intimidation at one time or another. So I just believe that we should not pass this bill. I'm asking you to vote no on SB 227. Thank you very much for your time.
Good afternoon. My name is Julie Burke, and I've heard all kinds of stories today about being intimidated and threatened as if it's only for one group or one person or whatever, and I want to reiterate what others have said. I too have been threatened and intimidated, but more importantly, I have a family member who was severely threatened, intimidated, and put in fear in the public school. But that, to them, it didn't fit in the box of what intimidation and hate and fear was supposed to be, and so nothing was done. So I guess I just want to say we can't go down the road of trying to put into law everything that is threatening or intimidating to someone. That's a very slippery slope, and that's not why I elect my representatives. So I hope you vote no on this. Thank you.
So we are approaching our 20-minute limit. I'm going to go to the phones for 3 callers. BPS, can you put on the first caller in opposition to SB 227?
Yes, Chair. If you would like to testify in opposition to SB 227, please press star 9 to take your place in the queue.
BYRUSHOJJATY. I pose this bill. It's very vague. What is considered racist? Is it racist to say that whites are being displaced by massive immigration also in Europe? The whites are experiencing massive numbers of discrimination? That the crime rates when it comes to black on white is several times higher than the other way around? That Arabs and Persians had black slaves? Question the vaccine? The fact that I showed the senator that about 1,000 years ago that there was racial differences based on civilization, which proved that it's more of a biological factor. What is considered hate? Now, why are they bringing up this bill? I believe it's because there's a massive awakening. We're realizing the real hatred is against Europeans, males, and straight people. I don't believe the Southern Poverty Law Center is a legitimate organization. One of their members actually committed violence. Many of the people that they considered hateful, I've interviewed them and met them in person. They met a Persian, by the way. And also the organization No Racism 1865, which I have all on video in the library in 2021, they started to raise their voice, they started tension, and they were all taking their side. And even last month when they had a rally, I just stood there and they threatened me. So what do we do? What are we supposed to realize this? Because I have this all on video. Fact is that diversity can lead to conflict. Not always, but oftentimes. It happens all over the world, even where my parents come from. And you're not going to stop me. If you pass this bill, I'm going to magnify 10 times. The best thing to do is to debunk our facts, not to shut them down. Thank you so much, and God bless European Americans.
Good afternoon, committee. My name is Jim DeGraffenreid, Republican National Committeeman for the state of Nevada, testifying in opposition to SB 227 on behalf of the Nevada Republican Party. Our founders held the First Amendment to be self-evident, but they understood that it was the first right that an overbearing government would attack. Congress shall make no law abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for redress of grievances. SB 227 seeks to limit both freedom of speech and how people petition their government for redress of grievances because one person's free speech is another's hate speech. The First Amendment wasn't written to protect the right of all citizens to say that puppies are adorable. It was written to protect citizens who expressed unruly, radical, and controversial ideas, such as Thomas Paine, who was convicted for seditious libel against the British Crown. In 2023, he'd be prosecuted using language against so-called hate speech as in SB 227. The bill seeks to weaponize government using a parade of horrible examples that no right-minded person would support as a distraction to sneak in censorship against anyone who might express a controversial opinion. Because they are so subjective, it's impossible for SB 227 to properly define intimidation or a symbol of hate, which are so vague in the bill as to be meaningless. What is a symbol of hate? It means something different to everyone, but it shouldn't mean anything to the government. The government doesn't have the power to shield an individual from the consequences of speech. For example, if my neighbor chooses to display an anti-law enforcement slogan on their front lawn, that's their right, just as it's my right to choose not to have anything to do with them. Government's only role is to be a fierce protector of the right to say anything, especially if someone finds it disagreeable. Sunlight is the best disinfectant for hate, bigotry, and racism. Government censorship disinfects nothing. SB 227 directly opposes free speech. It allows the state of Nevada to target anyone who says anything that someone else vaguely defines as intimidation and make them a felon. We have real problems in our state, actual criminals who deserve punishment and are currently walking free. Please throw this bill that seeks to suppress free speech, free debate, and free dialogue in the trash where it belongs. It has no place in any society whose government has a stated goal of protecting individual rights. Please oppose SB 227. Thank you.
All right, thank you, BPS. We're going to come back down to, actually, I'm going to go to Las Vegas. Are you?
Hello? Hello? Asked to unmute.
Oh, BPS, if we can, I'm trying to rotate here and go down to Las Vegas for in-person testimony. I'm not sure if that's someone at the table to give opposition testimony in Las Vegas.
No, ma'am, I'm here for closing remarks.
Okay.
Yes.
In that case, we'll come back up to
Thank you,
Carson
Madam
City
Chair.
for opposition testimony.
Good afternoon, Madam Chair and members of the committee. For the record, Attar Hasibullah, first name spelled A-T-H-A-R, last name H-A-S-E-E-B-U-L-L-A-H. I'm the Executive Director for the American Civil Liberties Union of Nevada. Today we're standing in opposition to this bill as currently drafted. Committee rules require such until obviously the bill presented is one that we could stand behind and support. We have been working with the senator as well as LCB. We're grateful for their their ability to speak with us and their constant communication in that regard, as well as the other stakeholders. We look forward to continuing that conversation to be able to address the bill in a way that we think will result in a constitutional bill moving forward. We think there are constitutional concerns right now. Again, we're looking to be able to address those. I also do want to thank everyone for the history lessons on the ACLU today, so I encourage you to renew your membership if that's the case. Had to sit through a minute and a half of other folks' testimony each time, so appreciate the shout outs. Thank you.
Good afternoon, Chair, members of the committee. Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office, to echo the sentiments of Mr. Hasibullah. We are testifying in opposition today per the rules of the committee. I do thank the Senator for the conversations that we've been having and look forward to continue those to get to a constitutional reasonable bill. Thank you.
Thank you, Chair. John Puro for the record from the Clark County Public Defender's Office. Again, we just want to thank the Senator as well for continuing to work on this so that we can adjust this to get in line with constitutional parameters and make a bill that works.
All right, thank you so much. I'm sorry, we have well exceeded 20 minutes of opposition testimony, and we have to allow people time to testify in neutral, as well as hear our other bills and go to our committees at 3:30. So I am going to conclude opposition testimony and move. Absolutely, you can submit your testimony in writing. I encourage you to do that. You can email it to the Senate Judiciary Committee. Our email address is on the agendas, which are out by the door, or our secretary can provide it to you. Anybody wishing to testify in the neutral position is invited to the table in Carson City or Las Vegas. Not seeing anybody, we will move to the phones for testimony in neutral on SB 227.
If you would like to testify in neutral for SB 227, please press star 9 to take your place in the queue. We have no callers to testify in neutral, Chair.
All right, I see somebody's joined us at the table in Las Vegas. Are you intending to give neutral testimony?
Yes.
All right, go ahead.
Hello, my name is Yesenia Moya, Yeseniamoya. I am testifying actually in support of this bill. Thank you.
All right. Seeing nobody else to give neutral testimony, I will invite the bill sponsor back up for closing comments.
Thank you, Madam Chair. I'd like to go to Las Vegas first for Reverend Bush, and then I'll close out. Okay.
Yes, Robert Bush, for the record, with the National Action Network. I just wanted to clarify just a couple things. One, the statement was made that there were not any Christian organizations that were represented. And I wanted to say that Bishop Derek Remsen represents Nehemiah Ministries, a group of churches across the country and also throughout Las Vegas that are Christian. And also, our organization, National Action Network, is unashamedly a faith-based organization that represents Christian organizations as well as other faiths. And then I wanted to say that at National Action Network that we maintain our policy of support for the freedom of speech as protected by the First Amendment of the Constitution. But we expressly adopt a position of zero tolerance, no tolerance of anyone who uses a noose to intimidate, threaten, or assault African Americans or our allies and violates the Constitution or right to life, liberty, or the pursuit of happiness. We are unashamedly and excited about this bill getting through the legislation and protecting the people that need to be protected. And so thank you, Madam Chair, for your time. Thank you, committee, for your time. And thank you, Senator Spearman, for carrying this bill.
Thank you, Madam Chair and members of the committee. For the record, I am still State Senator Pat Spearman, representing Senate District 1. I just want to take a couple of minutes just to address some things. And, you know, my dad used to tell me all the time that wherever I was, it was probably going to be a lightning rod, simply because I'm not afraid to tackle those issues that seem to be controversial, shall we say. And that probably has something to do with the way I was born, or where I was born. I was born in an elevator, freight elevator, in the hospital of St. Vincent's in Indianapolis. And I was born in the freight elevator because when my dad went into the front door to tell the receptionist that my mom was in labor, they said, colored people can't come through the front door, you have to go to the back door. And so they did, and by the time they got to the back door, I was really ready to get here. And so we got into, my dad and my mom got into a freight elevator, and there was trash on the floor. I remember my dad and my mom telling me very vividly that, you know, they were trying to step over, you know, old food and other types of trash. And Mom said there was a really sharp pain, and she passed out. And my dad said when she passed out on a bag of trash. And when the elevator got up to labor and delivery and the door opened, the nurses were standing there and said, "Oh my God, here's the head." As a matter of fact, the last birthday card that my mom sent me before she passed away had on there, the nurses called you Speedy because you couldn't wait to get into the world. You had to be born in the elevator. So that's kind of how I got to the world, and I'm not ashamed of it. It's part of our history, and that won't go away. Anyone who knows me knows that I always fight for fairness, for freedom, even freedom of speech. That's why I stood in 2017 and carried the Equal Rights Amendment in Nevada, even though people said that it was dead. That's why I joined with our majority leader to make sure that we got the most comprehensive Equal Rights Amendment anywhere in the country passed here in Nevada. And that's one of the reasons why I am very proud to be an ordained minister. I don't use my religion, you know, to tell people what to do or what not to do. I don't wear a big old cross, and I don't even carry a Bible. And for those of you who have heard me pray in the Senate, you know that when I pray, I acknowledge all religions. And so religion to me is something that's personal. And despite what some people think, I think when I appear, you know, unless I tell you I'm an ordained minister, you just think I'm somebody fighting for the rights of other folks. This bill is simply an opportunity for us to deal with a part of our history that nobody wants to deal with. Want to erase. But you can't erase it. And it's real. And there are people who are still experiencing that. You may not want to talk about it. You may not want to even teach it. But the history of the United States of America, which I am a citizen, and I am third generation free, meaning that my grandmother was born 15 years after slavery ended, so she was born free. My dad was born free, and then I was born free. But that tells you how close we are to a very ugly time in American history that we don't want to acknowledge. But we have to look at it. Because what history does is it tells us what happened, but it also cautions us and teaches us what not to do so that it doesn't happen again. This bill, with the amendments, will not do anything to curb free speech. It is a bill simply to address the rampant hatred that once again is rearing its ugly head in our country. And this country is so great that we should not tolerate hate at any level. A lot of people will disagree with me, and that's their right. A lot of people will agree with me, and that's their right. I just want to say, for the record, I wish I didn't have to bring this bill. I wish everything in America was peaches and cream and ice cream all day long, but it's not. And the reality is there are still people that are experiencing the ugliness of systemic racism and hatred. Let me say this in closing. There's a word that we use, and I stopped using it once I learned its origin. But most people use it, and they have no idea what it means. The origin of picnic. And picnic was initially started as people gathered to do things like eat and celebrate, and it would be at a time when there was going to be a hanging. So I don't even use the word picnic anymore, because it's something that's very ugly and it means something very, very bad. In this country, we've come a long way, but we have a long way to go. And it is my hope and my prayer that my children, your children, our grandchildren, our great-grandchildren, and generations to come will be able to look back on what we've done, not just here today, but throughout history, to say we acknowledge those things that we have done that have not been well in the sight of God, and we have worked hard to make the wrong right. I tell people all the time, when you bury me, put on my headstone, unafraid. Thank you, Madam Chair.
And thank you, Senator. And thank you, everybody who was here to participate. We appreciate all of you being part of the process. And I'll reiterate that anybody who did not have an opportunity to speak today can submit their comments in writing. I read all of those comments. I encourage the members of my committee to read all of them as well. And with that, I will close the hearing on SB 227 and open the hearing on SB 359. And a little bit of housekeeping. I think we are inviting folks in the overflow room back into this room right now, as that room does. The overflow room will be used for another committee hearing momentarily, and I think we will all fit in here for this hearing, I think. All right, go ahead whenever you're ready.
Good afternoon, Chair Scheibel, members of the Senate Judiciary Committee. For the record, my name is James Orenshaw. I represent State Senate District 21 down in Southern Nevada, and I'm very, very lucky to have with me Assistant District Attorney Bridget Duffy, joining me to help present Senate Bill 359. She's also going to be presenting a friendly amendment that we've been working on, and for anyone who's spent a little time working in juvenile justice knows and respects Ms. Duffy for the incredible work she does on behalf of our children. I've had the opportunity to work with Ms. Duffy through the years because, as most of you know, I'm a deputy public defender in juvenile court in Clark County. And, you know, everybody likes to kind of pick on attorneys and hate attorneys, but I think Ms. Duffy and I are pretty lucky because working in juvenile delinquency child welfare, we work in an arena where defense attorneys, prosecutors, the juvenile court judges, the probation officers, the social workers, we're all focused on one thing, trying to see our client, our child, become a success, not be arrested again, not be brought in on a violation of probation, not be sent to a youth correctional facility. And my biggest successes are clients I never see again. I know that's kind of the antithesis of private practice, but if I don't see a client again, I know it's been a success, and Ms. Duffy has been just tremendous in trying to help children through her career, and I'm lucky to get to work with her. Senate Bill 359 comes out of my work defending children in Clark County. I've had many conversations with clients and with probation officers through the years where children would have completed all the terms of the juvenile probation, but for community service. There was a problem finding someone who would accept them, finding, a place where they could perform the court-ordered community service. Sometimes we had issues where juvenile judges and hearing masters might have wanted some flexibility in terms of what kind of community service to order and what they thought would benefit the child the most, but the Nevada revised statutes, for many cases, didn't give them that flexibility. Senate Bill 359 and the amendment that Ms. Duffy and the District Attorneys Association is presenting, I believe will give children a better chance to be successful on juvenile probation and to be geared towards things that will really help them. So with your permission, Chair Scheibel, if I could allow Ms. Duffy to walk through the amendment, and then I'm happy to answer any questions you or the committee have.
Good afternoon, Chair Scheibel and members of the Senate Judiciary. First of all, thank you, Senator Orenshaw, for your kind words and for working with me and the Clark County Department of Juvenile Justice Services. While this amendment is on our letterhead from the District Attorneys Association, it is a collaborative piece from our local Department of Juvenile Justice Services. When the original language of
I'm going to pause you real quick. We don't have the amendment on Nellis.
Yes, let me explain that. I found it thanks to Liz Flores from Washoe County. It's under the last bill, 277.
Oh.
Everybody was texting me saying, "Where's your amendment?" And then somebody stumbled upon it in 277. So if you want to pull it up in there. 227.
227.
Thank you, Senator.
All right. Thank you. Everybody got it on the committee? And if anybody needs a printed copy, we can grab one for you. Just, I don't know, give a signal or something.
Yeah, I don't know how all that works in the background.
So, it's right yeah. Go ahead.
Okay, great. So, so when the original language in 359 came out, you would see it really in an effort to help kids get through probation and be successful. It actually, since we are limited in finding places for kids to go based upon statutory construction, they made an attempt to reduce the hours that a child would do community service instead of expanding the ways that a child can get community service. So as a group, we decided that it would be better to look and expand ways that a child can get community service rather than reduce the amount of hours to do it. So in doing that, we looked at the federal work of the Office of Juvenile Justice and Delinquency Prevention to talk about how community service really is an important and valuable tool, and that meaningful community service can go a long way to restoring victims and reconnecting youth with their community. And community service should be a value to both the community and the benefit of the child providing the services. So in our amendment, which I will walk you through, it defines community service a lot more broadly with in Section 1, community service is a community-based activity with the goal of or design that is designed to increase the child's empathy toward a victim, increase the child's accountability for the harm committed by having the child provide a service to the community, develop critical thinking and problem-solving skills, gain a better understanding of how to make constructive changes, develop a deeper understanding of community problems, gain a sense of individual effectiveness, and recognize the need to have a positive involvement in his or her community. Community service may include community-based activities that facilitate civic engagement. So think about volunteerism, activism, clubs at school that would be designed to build leadership skills for a child. Enhance connections between the child and his or her community, enhance the child's life skills, increase the child's employability through basic job skills training, and facilitate connections with positive adults and youth peers in his or her community. So this broadened definition will then allow children to gain community service through things such as carpentry class in a high school, through pro-social activities that could involve sports or clubs. So it's really about connecting that child to a community. In Section 2, these would be cases that do not actually go to court because they are informal supervision. So cases that it would allow a juvenile probation officer to work informally with the child. And in that section, we added that probation officer during the informal supervision could ask the child to attend or participate in counseling or psychological treatment. In Section 3, we kept the removal of Section 2, of Section 3. That is because in those cases, those CHINS offenses for first and second time marijuana or alcohol, those cases don't go to court, so the juvenile court would not be involved to order a child to do any community service. That would be handled through the informal probation under 62C 200. In Section 4, Section 4, Sub 1, Sub B, we struck the school, that the child may do the community school service at the school of attendance, or someplace where the child is participating in tutoring or extracurricular activities. That is because a political subdivision is actually considered a school district. So it would seem redundant, but I think in talking to some partners, we'd like to specifically call out that they can do this community service within the school. So just to make sure there's no doubt that a political subdivision is a local school district, I believe we'll probably further amend this to add specifically local schools. We did add in that the program could have a primary purpose to build job schools and increase the employability of the child. That really increases our community capacity and positive outcomes for kids. So think culinary trainings, any type of union trainings that these kids can get in the community would be included in community service. In Section 4, Subsection 2, added to the language that the court shall make, or that the person who supervises the community service shall make reports to the juvenile court, and the juvenile court may require those reports. We added that the court could have the child, him or herself, inform the juvenile court of what goals in Section 1, the participation in the community service assisted in helping the child achieve. That comes out of some of the federal guidance on community service, that it's good to have the child connect what they did to actually restoring themselves and the community. I know there may be some questions about that and amendments still to come with regard to that section. On Section 5, I removed the fine. I didn't even know we were still fining on truancy. So for the habitual truant, removed the fine and added back in the language of 8 hours, but not more than 16 hours of community service, and that was for a first offense. For a second offense, the fine remained. I didn't want to be so bold as removing all of the fines, and added back in not more than 10 hours of community service and compliance with the requirements set forth in both of those subparagraphs 1 and 2. Then further down, added in that there could be the additional 10 hours of community service added in for these truancy issues. Section 6 is just some conforming language. There was in the original bill a lot of replacing community service with participation in counseling and psychological treatment. But really, those were two separate things. There's community service, and then there's counseling. And so to replace those hours, if we can expand what a child can do, we are much, I believe, as a community better off to getting that child on the right path. And then counseling is an addition. In Section 7, added back in the 200 hours of community service for a first offense firearm. Our firearms offenses are our most serious offenses and our kids at the most high risk with the highest level of needs. So having them do some pro-social activity and connecting to the community to find mentors or job building skills, I think is much more beneficial to the community. And at 200 hours, we can get there. I know that might seem like a lot of hours, and so I think we are in discussions with going up to 200 hours. Adding back in also the existing language of at least for a second offense firearm, at least 200 hours, but not more than 600 hours of community service. The rest of the amendment was taking out some of the language that had substituted community service with counseling or psychological treatment, and limiting these specific hours of community service, because as I started with, the goal isn't to say kids shouldn't be out there doing things that are connecting them to the community and we should reduce that. It's where can we connect these kids to the community so that the kids have better outcomes and our community is better for it. So with that, I will take any questions that you have, and if I may, I can just put on the support of the Nevada District Attorneys Association at this time. Thank you.
All right, thank you. Questions from members of the committee, starting with Senator Wynn.
Thank you, and thank you, Senator, for bringing this bill. I have always hated how traditional community service and working in the community has turned into like a punishment and a penalty. And I think that is a terrible way to view service in the community. And I think when it is treated as a punishment, we are not getting lifelong volunteers in some of these organizations where I think it's desperately needed. So I do appreciate the expanded definition. And I'm assuming that you made that generic in the amendment. And I apologize, I just saw it after I realized it was misfiled online. You increased kind of those parameters with the goals and what those are because they were just more broad to allow a little bit more discretion. Is that correct?
Bridget Duffy for the record. Yes, we really wanted to make sure that, especially for let's start with young kids. Young kids, it's really hard to find community service for young kids. A lot of places don't want to supervise children that are 12, 13 years old, liability issues. So knowing that those are very formative years for education, getting a child that can do tutoring with a great mentor, expanding it, because right now we are having a problem coming to agreements in court over what qualifies. So this was our agreement. Like, we need to look and define it differently. It should not be a punishment. It should be a connection. It should be a teaching experience for a child, and set them up for success because we can get those skills out there.
And Chair Scheibel, if I could jump in, James Orenshaw, State Senate District 21. I believe that under the language here in the District Attorney's Amendment, something that would qualify to satisfy community service hours would be mentoring programs. And as a deputy public defender who practices in juvenile court, I've represented children who've been in some of these mentoring programs, and the bond and the connection that they develop with this big brother, big sister type mentor who's just there for them, and sometimes will drive them to school, take them to a movie, just spend a lot of time with them, that a lot of times there's no one else who can do that. That really, I think, has led to successful outcomes for a lot of kids I represent, and I think that this could really help them make positive progress towards completing their probation versus having maybe a goal that's not realistically reachable.
And then my follow-up question is I understand now that if this bill was to pass, there would be an expanded definition of what community service entails. And so I'm assuming that part of that went into the thinking of increasing some of those community service hour requirements. Some of them seem just incredibly high, though. And I'm wondering, and you might have different perspectives being on different sides of the aisle, so I appreciate you both being at the table. But what is the average amount of community service that these hearing masters or judges are imposing on this? I'm thinking of 600 hours of community service. I mean, someone is going to age out of the system before they are able to accomplish that. And I would hate to make these levels so high that it puts there's already a burden on these children that are in this system, and a lot of times they are coming from environments where they do need mentoring programs and they don't have that family support. And I know that this seems like it could put an additional burden on families that are maybe already struggling to do that. One of these, I think you said, was 600 hours of community service. Even at 200 hours of community service, that's like 4 hours a week. So I'm just curious on what the thought process was what are the average amounts of community service that are being imposed currently?
Bridget Duffy for the record. Thank you for that question. So no thought process, because that's already language that's already required. So we didn't make the decision to add extra hours. The original bill reduced the hours in an effort to say we can't find enough places for kids to go that meet what we can do right now statutorily. And instead, the decision we talked about as a community was keep the hours the way they are, but expand what a child can do. So the 200 up to it's up to 600 hours for a second offense firearm was already the language in the bill.
And I guess my
In the
question
statute.
is there, what are you seeing being imposed as far as community service? I mean, there's a huge difference between like something that gets 8 hours of community service and something that gets 600 hours of community service. So I'm curious what you're actually seeing in practice.
Chair Scheibel, James Orenshaw, State Senate District 21, to you and through you to Senator Nguyen.
You can go direct.
Thank you. Certainly my experience as practicing down in the juvenile courts is I feel like the juvenile judges, the hearing masters, certainly would want more flexibility in terms of being able to assign what they think would be appropriate, what they think, based on the other orders, the child can complete successfully. And I think here this bill will go a long way towards giving children more flexibility. And I know that there might be some tweaks we're talking about to the amendment language. So I don't think this is final amendment to look at some of those issues. But I certainly get the feeling that I think that the hearing masters, the judges, in a lot of cases, I don't want to speak for them, but I feel like maybe there's certain times when their hands are tied by statute that maybe they wish they had more flexibility because perhaps, a mentoring program or some other kind of pro-social activity would be more effective for the child's success versus old-fashioned traditional community service that a lot of us think of, in terms of the adult system.
Last question. I was pretty sure we had passed some legislation. I think it was in 2019 to get written. I'm sure Ms. Duffy would know. Didn't we pass some legislation to eliminate fines? Was it just fines or fees for juveniles? And so I see those in there. So if, I would love to hear from legal if they know. I think it was Speaker Yeager's bill in, I think 2019 maybe. Look, you're making a face like you know.
Carly O'Krent, for the record, I need to look into that. I'll get back to you.
Because if it does not apply, I would like to see those removed because I think it probably should have if it wasn't.
And James Orenshaw, State Senate District 21, Senator Nguyen, thanks for pointing that out. Yeah, that was Speaker Yeager's bill. That was a project I think that some law students up in California had brought to him. And I appreciate your commenting on that, and maybe that needs to be corrected if that wasn't caught in the original bill.
Right. Bridget Duffy, for the record. That's why I took out the first one because I was surprised it was still there, and so I struck it for the first offense, but I didn't want to be as bold to say, because I don't remember why they left it in the juvenile statute.
All right. Senator Don Darrell-Loop.
Thank you, Madam Chair. What if you had, since the hours are a lot, what if we had some, I want to say, tiered approach? In other words, if we knew something worked with kids, whatever it is, in those situations, what if we gave them, I don't know, more credit to do those things? So if we knew that being with a big brother, big sister type thing was very beneficial and worked with a lot of kids, and they had 200 hours to complete, what if we gave them an hour and a half if they did that, or an hour and 15? I don't know what it is, right? What the answer is, but what if we encourage them to do those things so that we got them in there to do those things rather than dragging out the process and making it something that they come to dislike just because they have to keep doing it. I'm just trying to think creatively about kids who get in trouble who may not have parental support, kids who get in trouble who may consistently get in trouble, and it's for lots of reasons, right? So I'm just trying to think of ways that maybe we could encourage them to do some things that would really give them some help. I don't know if it's, I'm trying to think of a real concrete example, but I don't know if we told them that they needed to go to counseling with XYZ, we gave them a little boost to do that so that they were encouraged to do it rather than, groaning about doing it. I don't know if that's reasonable or not from my recollection of family court services or not. So just.
And, Your Honor, Chair Scheibel, through you to Senator Dondero Loop. I know there were programs in the past, I know Ms. Duffy was involved with the program that got kids involved in basketball leagues, and if something like that, pro-social activity through this bill and the amendment would count towards the community service hours, I think that that would be a way children could work towards being successful on probation, be involved in positive activity, whether it's a sports team or maybe extra play at school or a club. I think that there's a lot of avenues where maybe kids won't think, oh, I have to go show up and perform community service, and maybe it will be something that will lead to more positive outcomes, be able to get their orders done, get their case closed, and put that chapter of their life behind them. And as we were saying earlier, the greatest joy for us is to not see a child come back. So I think that this bill and the amendment has the potential to do that. In terms of adding more credit, that might be a separate bill.
Right. And I guess someplace in my mind, I think I remember that, and not maybe legislatively, but maybe at family court at one point, I can't remember if they got, if they went to school consistently, didn't miss school, they got certain grades, or they went to certain classes, or they did whatever, right? It helped take off some of that time, if you will. And I just guess that's what I was trying to encourage, is if we gave them, I don't care if it's an extra 2 hours, if we gave them a goal that wasn't just punishment, I guess is where I'm looking at it. So thank you very much.
All right, other questions? Senator Hansen.
Thanks, Madam Chair. First thing, it's great to see Bridget Duffy. How many years have you been doing this now? I came in 2011, and you were here then, I think. Okay, just right after that. The reason I bring that up is I don't think I've ever opposed a bill you brought. I mean, we have some tweaks to do, but again, I think this is an excellent one. I think we do need to recognize, though, like for 600 hours, we're dealing with what we call them children. In many cases, we're dealing with 16, 17-year-olds that brought a weapon, a gun or something to the school. We're not. It's not like children who, my day had chewing gum in class or something. So these are fairly serious things. Now, question in my mind, though, is you want to do more psychological stuff, fine. What's the success rate? We're talking in the adult prison, we talk about recidivism rates. Do you guys monitor recidivism rates? And if you do, how successful the psychological side of what you guys have been doing?
Bridget Duffy for the record. It's good to see you too, Senator. Thank you for the questions. We struggle with figuring out our recidivism rates. Several reasons we can talk about later, but sometimes it's because our two case management systems between the adult system and the juvenile system do not speak to each other. So I don't know if we have a kid at 16, if they stayed, on the great trajectory when we left them. So we do struggle with that. As far as how much, sending a child for a psychological evaluation in classes actually assist, I wouldn't be able to tell you. I can tell you that Senator Orenshaw mentioned a program I was involved in where I actually went with kids who were on juvenile probation. Some were sex trafficking victims, some were armed robbery kids. And we spent Saturdays at a training facility and just really worked together, critical thinking skills, cheering each other on when, building that empathy and leadership skills. And there are many kids that are now adults that went through that where I was there and involved that still contact me to tell me what they're doing in life. And it was positive because we got them around positive people with that energy, and it helped kids see the community, me, as more than a person wearing a badge, and helped me see these children as more than their crimes that they committed or delinquent acts. So I can just tell you from my own personal experience, this is very important to me because I think we can make an impact when we can connect a child to what they will succeed at and put them on a better path. And when you think about 600 hours, if we can get them into a program, Like one of our local high schools has a carpentry program. If we can get them in that program at their school, where they're in school 5 days a week and they're getting hours for sitting with that teacher, that's going to get them pretty close for their second firearm offense to that 600 hours. Culinary programs, forestry programs, we have it in Clark County, and I think you'll hear from my partners in Washoe County as to what they have available today. But I'm looking forward to expanding these activities because I really think it'll make a difference for kids, and it's not a punishment, it's a connection to community, and that'll be better for everybody.
Well, I just want to thank you both for what you're doing, and your longevity says a ton about your sincere commitment to those kids. And that's why I wanted to compliment you both for doing that. And in all seriousness, when Bridget Duffy speaks, people listen, and I'm one of them. So I'm sure there'll be some cleanup on the bill, but the overall concept, I'm sure if you're behind it, is excellent for the kids that are in trouble and trying to work their way out of, hopefully not a spiral into state prison. Thank you, Madam Chair.
And Chair Scheibel, James Orenshaw, State Senate District 21. Senator Hansen, thank you for your comments and those amazing programs that Ms. Duffy was getting kids involved in and is still getting kids involved in. As to, you brought up firearms in school, and certainly we have cases where a child's arrested with possession of a firearm, and the statute says that 200 hours of community service is ordered for the first offense. Very often, we also get children who, bring a BB gun, bring a toy gun, and the statute still requires that ordering of the 200 hours community service. And I'm not in favor of kids bringing BB guns to school, but a lot of kids, they may not be up to speed on that and know that that the BB gun that someone gave them that they think is a toy, that certainly, we realize how dangerous it is to take it to school because people might think it's a real gun, but a lot of kids don't realize that. But the community service is the same, whether it's a real gun or a BB gun that the child is in possession of.
All right, other questions? Senator Stone.
Thank you, Madam Chair. I know we're running out of time, so I'll try to make it quick. Deputy DA Duffy, it's very nice to meet you, and I really appreciate your passion for kids. And I'm speaking as a father of a 16-year veteran of the Riverside County District Attorney's Office who is now an elected judge. So I'm very proud of him and proud of the work that he did. And Senator Orenthal, I don't know if you remember, we met at the Grant Sawyer building right after I got elected, and I sat next to you and I said, this guy's got a big heart. And today I think it really shows that you do have a big heart for the kids, and I want to thank you for your service in being a public defender. So now quickly to the questions. You talked in the bill about the challenge of finding community service programs for the kids to get involved in, and I can certainly understand. And then in lieu of some of those programs, you were recommending some psychological treatments. But I also know that we have a shortage of behavioral health people in Nevada, and I was wondering, number one, how you're going to accommodate that. I'll ask my three questions real fast. And then in all the programs that I see listed here, there's one element that seems to be missing, and that's the parents. Parental involvement. And so when I was an elected official in the city of Temecula, we had a graffiti problem. And so we passed what I thought was the toughest graffiti ordinance in the state of California. I still think it still is. And what it required was that if a juvenile got caught tagging, that they would have to do community service abating graffiti, but they didn't do it alone. They had to do it in the accompaniment of both their parents and had to pay the mitigation costs for the damage that they did. As a result of that ordinance, our graffiti crimes went down to practically zero. So that's the second question, was about the parents. The third question is about firearms. When you have a second episode of a child having a firearm, to me, the flags are really going up, that something isn't working in this child's life. We had a similar issue in the county of Riverside, where I sat on the Board of Supervisors there, and we had a mandatory program that if you had a firearm, you had to go to a juvenile detention center, and you had to hear a juvenile detainee that was going to be in prison for the rest of their life. And I'll never forget this as long as I live. I wasn't a supervisor, but for more than maybe a couple of months, and the parents had to come with the kids that were caught with a weapon. And I remember there were two juveniles. They were 17 years old when they murdered a couple of people. and they were going to be transferred at 17 years old from a juvenile facility to an adult facility and spend the rest of their life in prison. And they opined in front of all these kids, don't make the same mistakes that we did. We made a split second decision that was not a good decision, and we're going to pay the price for the rest of our lives. And there was probably at least 100 kids that were in the audience, and the parents were there with them. I'll guarantee you that was a very moving presentation that maybe that got the attention of the kids to say, yeah, that's something I definitely don't want to do. I don't want to spend the rest of my life in prison, and making a stupid decision like these two guys did could end up us in going there. So I just wanted to get your opinion on embracing a program like that. And again, thank you for your service.
James Ornshaw, State Senate District 21. Senator Stone, thank you for your kind words. As to the lack of personnel in behavioral health, I know with our medical schools here, I think we've got a better shot at graduating people who want to try to help children and can try to work in whether it's social work, clinicians, but that's not going to solve the lack of personnel. I know that there's other efforts with reciprocal licensure that we've had through the years in terms of trying to attract people from other states, and I hope that will continue, because that lack of personnel, that's very difficult. Parental involvement, it's really, it depends on each case is different, how involved, parents can be, want to be, and I wish there were a magic bullet that I could see that would solve that, because it certainly is different. I see cases where parents are very involved and are able to be very involved. I see other cases where parents are very not involved at all, sometimes because they can't be, because they're so strapped working so many jobs and don't have the time to be able to, and other cases just because they're not interested. It's a real challenge, and that I'm certainly interested to hear what you felt worked in other states, but I don't have an answer to right now.
Bridget Duffy for the record. Senator Stone, I'm going to give you so Section 4, existing language already allows the court to order the parent to participate in the community service.
Good.
That's already in statute here in Nevada. So if you have the amendment up, Section 4, subsection 1, the juvenile court can order the child or parent or guardian or both to perform community service. That's already law in our state. And the amendment that's presented, the using counseling or psychological treatment to replace community service is removed. That will be a separate part of the child's probationary terms, separate from community service. And as to your firearms thoughts, I do think those are very impactful for children to listen to, and we do have some great gang programs in Clark County that talk about similar things.
And then lastly, in Clark County, do they have youth courts?
No, I hate Bridget Duffy for the record. Oh, do you mean like trial by peers? I'm sorry,
Yes.
that's a question.
Yes.
Yes, we do.
Okay, great. Thank you again.
All right, any other questions? Not seeing any, we will move to testimony. We're actually going to go to Las Vegas first, because I know that they're trying to turn that room over for another hearing. So anybody in Las Vegas in support of SB 359, come on down to the table, and you will each have 2 minutes.
I hope you can hear me. Greetings. My name is Jageda Chambers. I'm actually a constituent of the Honorable Chair's Senate District 1. Definitely in support of this piece of legislation. Appreciative of Senator Ornshaw always being someone who is cognizant and concerned about the youth and their well-being and their life outcomes. Hopefully the language can fit it enough to where all the committee can get behind it. Thank you so much for your time.
Hello, my name is Yesenia Moya, Yesenia I'm here in testimony in favor of this bill. I'd like to thank Senator Ornshaw for bringing this forward and for continuing to champion our youth. I'm hoping the same as previously, that we can work on this language and make sure that our youth are put first and foremost so that we can continue to grow as a community. Thank you.
All right, looks like that's everybody wishing to testify in support in Las Vegas, so we will come down to Carson City. Go ahead whenever you're ready.
Good afternoon, Chair Scheibel and committee members. My name is Nick Shepak, Nickshepak. I am the State Deputy Director of the Fines and Fees Justice Center. Fines and Fees Justice Center supports legislation that expands the definition of community service for everyone, and we were very happy to see that Senator Orenshaw brought this bill specifically for juveniles. There's a few main points that we want to touch on here, and one, I want to first start by saying that we agree with the reduction of the hours in the original proposed bill. If I look back at my life as an example, I had two parents for most of my childhood. I participated in extracurricular activities. I had no obligations to work. If I had been sentenced to community service under these guidelines, I would have had many options. Many of my neighbors in my neighborhood came from single-family immigrant homes where they worked jobs after school on the weekends, helped watch the kids. And some of these, the amount of hours that is necessary to complete would have been very difficult for these people, while very easy for me. It was expanding the options to do extracurricular activities, in-school activities, these things that connect you to your community and better yourself, we believe is extremely important to foster a trust in the justice system and to ensure that when the kid completes his probation, he actually comes out with some skills that are beneficial. And I think lastly, one thing that hasn't been talked about is we talked about Clark County, we often talk about Washoe County. In our discussions with many of the rural counties, so we talked to a public defender out in Eureka who let us know that the only community service options they had was cleaning the police cars if they were dirty and hadn't been cleaned recently, or picking up trash on the side of the freeway. This is not necessarily age appropriate or safe for juveniles. But what they do have is definitely a school and extracurricular activities. So when we're thinking about expanding and allowing kids to access community service, if we think about our rurals, we believe this piece of legislation can have a great impact. Thank you.
Jonathan Norman, Norman, Chair, members of the committee. I'm with the Nevada Coalition of Legal Service Providers. It includes Legal Aid Center of Southern Nevada and Northern Nevada Legal Aid, which represents kids in foster care. Obviously, a lot of kids in foster care have crossover cases, so they're in foster care, and they also have juvenile justice cases and are represented by the PDs. I think this is a really thoughtful piece of legislation. I appreciate Senator Orenshaw bringing it. I agree with DA Duffy about 95% of the time, and this is one of those. I think expanding the opportunities for kids makes a lot of sense. We've seen CAP kids, so kids we're representing in foster care that are having trouble meeting that goal, which is certainly of community service, and that's always exacerbated because they're in foster care. And so I think this creates a lot of great options. So we're in support of SB 359. Thank you.
Good afternoon, Chair Scheibel and members of the committee. My name is Jeff Rogan, R-O-G-A-N, and I am with Clark County. Clark County, on behalf of our Department of Juvenile Justice Services, supports the proposed amendment to SB 359 and supports SB 359. As you heard, since the COVID-19 pandemic, there's been limited opportunities for juveniles to perform community service, especially for those who are under the age of 14 and those who live in the less populated areas of the county. This bill would remedy that and allow those juveniles to complete their probation in a timely fashion where that hasn't always been the case. More importantly, from our perspective, is that this bill and the proposed amendment transitions our understanding of what community service means away from these manual labor type assignments and towards something more that will encourage civic engagement, enhance life skills, and keep children involved in their communities and involved in their schools. So we ask you to support SB 359 and ask you to support the amendment. Thank you.
Good afternoon, Chair, members of the committee. Erica Roth on behalf of the Washoe County Public Defender's Office, testifying in support of SB 359. I echo the sentiments of those who've testified before me, and also simply add that expanding opportunities for juveniles and for community service, it just makes sense, and we want to set them up to succeed. Thank you.
Thank you, Chair. John Puro for the record from the Clark County Public Defender's Office. We support this measure and thank Senator Orenshaw for bringing it forward.
All right, thank you all. We will go to the phones for testimony in support of SB 359.
Thank you, Chair. If you would like to testify in support of SB 359, please press star 9 to take your place in the queue.
Hello, my name is Elizabeth Flores, Elizabeth Flores, Florez, and I am the Director of the Washoe County Department of Juvenile Services. I am calling in support of this bill as amended. Initially, I was opposed due to concerns around the allowance of therapy in lieu of community service. I am in support as amended not only philosophically, but there would have been a significant fiscal impact to counties. In Washoe County, community service is not viewed as punishment, but as an opportunity to assist youth in gaining empathy as part of their development and to give back to the community. We also have the benefit of operating a work program where our field supervisors counsel participants throughout the day to connect their behaviors to the impact on their victims who experience fear, trauma, and financial loss as a result of the juvenile's behavior. I thank Ms. Duffy for her amendments that remind us that our system must be balanced to promote youth development, promote community safety, and support victim restoration. Thank you.
There are no further callers to testify in support, Chair.
All right, then we will go to testimony in opposition, again starting in Las Vegas. I don't see anybody coming to the table in Las Vegas, so we will go to Carson City. Go ahead whenever you're ready.
Good afternoon, Chair Schreibel and the Senate Committee on Judiciary. My name is Chris Reese, R-I-E-S, and I represent the Las Vegas Metropolitan Police Department. At this time, we are opposed to this bill as written. While we appreciate expanding the avenues to satisfy community services, we are seeing an increase in school and gang violence involving juveniles, oftentimes involving the firearms. Decreasing the hours of community service that is meaningful will only make this worse. We look forward to working with Senator Orenshaw on SB 359 and hope that we can get to a position of support. But at this time, we are in opposition. Thank you.
All right. I don't see anybody else coming to testify in opposition here or in Las Vegas, so we'll go to the phone for testimony in opposition.
If you would like to testify in opposition to SB 359, please press star 9 to take your place in the queue. There are no callers to testify in opposition at this time.
All right. Anybody wishing to testify in the neutral position in Carson City or Las Vegas, please come to the table. Not seeing anybody, we will go to the phones for testimony in neutral.
If you would like to testify in neutral for SB 359, please press star 9 to take your place in the queue. There are no callers to testify in neutral.
All right. Would the sponsor like to make any closing remarks?
Chair Scheibel, members of the committee, thank you so much for hearing Senate Bill 359. I believe that the bill and the amendment has the potential to not only help kids succeed on probation, but to perform their community service in ways that can really help them with a lot of the issues they're facing and not become return customers. And with your indulgence, Chair Scheibel, if Ms. Duffy could just have a minute.
Bridget Duffy for the record. I just want to thank you all for considering this bill. I think it will go a long way, as you can see from even across the aisle in our day jobs, that what we can do with this is really support those children and make better outcomes for our community. Thank you.
Absolutely. Thank you for your presentation and everybody for being here to testify on the bill. I will now close the hearing on SB 359 and move to public comment. Anybody wishing to give public comment in person is invited to the table now. But since I don't see anybody coming to either table, we will go to the phones for public comment, please.
If you would like to provide public comment, please press star 9 to take your place in the queue.
Hello, everybody. This is John Carlo, the young gentleman from Las Vegas. And I just would like to comment basically having to do with the assistant DA. And I want to make sure that she has everything she needs in her office to do an effective job. Because I don't want to hear about people going to her office and her not having everything she needs. And what she's been promised, her office being updated, files being updated, she needs to have the best of everything when it comes to these children. And also what we really need to be looking at is reforming, amending the 1994 bill that made it illegal for public schools to discipline children by corporal punishment. Because like I will keep saying, I grew up in North Carolina where one of the best principals was a black woman, and she taught me a lot, and she spanked me. I still remember that to this very day, and we need to start disciplining these kids at a very young age so they don't get to the point, because they say an ounce of prevention is worth a pound of cure. And that's what we really need to be focusing on, the public education system. And we got, you guys need to let us know, the community, if you need some programs for kids to get involved. No one's talking to me. No one's talking to my church and what you guys need. You guys need to be better communicators. But I think that's going to be all for today. I do hope that everyone, and Mr. Stone did a great job. I think he brought a lot of good points up today. So anyways, I'll end on that. Hope you guys have a great day.
There are no further callers for public comment at this time.
All right, then that takes us to the conclusion of our meeting. We will meet again, same time, same place tomorrow. And until then, we are adjourned.